Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for TWiT specials is provided by Cachefly at CACHEFLY.com. This is TWiT special number 137, Apple versus Samsung, the verdict. Breaking news is brought to you by Slingbox, which can turn your iPad into a television. With the iPad app from Slingbox, you can watch your home TV on your iPad anywhere you go. Check it out at slingbox.com/twit. I just got here, but I'm told that the judge is reading the verdict.
Yeah, they I believe it's
privately.
They've said it's about 10-15 minutes before we're going to start hearing anything.
Okay.
And Judge Koh has affirmed that she doesn't want to release the jury until everything is clear. So this isn't going any further than this afternoon.
It's really kind of surprising, frankly.
Yeah, it was really quick, right?
The judge said, according to the San Jose Mercury News live blog, the judge has indicated it will, quote, take a while for this verdict to be read and finished.
Great.
It's 3:30 in California. Normally, on a Friday, court usually adjourns early.
I thought you said it would take a while to read this verdict and finish.
That's what they said. So, and I have I have tickets to a baseball game at 7 tonight, so I'm not staying here if it's going past too late.
Oh, come on.
Judge also said if there is obvious confusion in the verdict form, by the way, a very long 20-page verdict form. The judge said if there's confusion in the verdict form or mistakes or unanswered questions, she could send the jury back. And that's what she's doing right now. Judge Lucy Koh reviewing the jury's verdict forms to make sure. Apple's two attorneys, top attorneys, Harold McElhenney and William Lee, are not there. Like most of us, I think they did not expect a verdict anywhere near this quickly.
Now, she had a puzzling statement. She said she'll take a look at the decision to make sure everything is fine. But if something's obvious, like damages for invalid patents, she thinks she'll send them back.
Yeah.
So, but we don't have a decision on which patents are invalid yet.
Well, and this is, again, and unfortunately we're hampered a little bit. You know, can you try to get Denise Howell on the line?
Yeah, has anyone contacted her? Like, does she know that we're about to call her? Or?
No. But I would, Potter's mic is wrong or off. Just in case.
Is it a new mic?
It is a brand new mic.
It is. He's on number 4.
Oh, okay. I didn't have that up. All right.
And is Ayaz gone? Because I would like to get I'd like to get our legal team in.
Is gone. Is not here.
Somebody text Ayaz, and let's see if we can get Denise Howell on the horn. Do we have any producers here? Karsten, can you work on that? Because I think we need some expertise, some legal expertise on this one. But I'm so glad that Father Robert Ballecer's here. He is the host, of course, of This Week in Enterprise Tech. And like everyone in the tech industry, I think has been following with interest this amazing trial.
Well, this is a huge decision, not just for mobile devices, but really for the consumer electronics industry in general. This is going to test the validity of some of these stockpiles of weaponized patents.
Yeah.
This is the first time we've had two big companies go head-to-head, not do any settlements, not do any cross-licensing, and just let it lie with the jury.
Well, and let's not forget this has been hugely contentious. The judge, before the trial began, asked the CEOs of Samsung and Apple to meet. They met for a day in San Francisco, could not come to an agreement. And then again before, just a couple of days ago, before she sent it to the jury, she said, this is going to be bad for everyone. If you don't settle, I still have hope. Go talk to each other. The two CEOs spoke, Tim Cook from Apple and the CEO of Samsung, whose name escapes me, and could not come to an agreement. So this is unusual. In a case like this, usually they settle, I think, before you get this far. And I think the judge's point was you are trusting a highly technical matter that will have huge economic consequences for one or other or both companies, and you're trusting it to a jury of people who are not experts. And I think there must be some trepidation on the part of both Apple and Samsung that the jury has come in so quickly on this.
Well, there's a lot of legal experts who are saying that a very fast decision like this typically favors the plaintiff. But as Jason was saying earlier, there's two patents here. Both Samsung and Apple have claims of patent infringement.
Yeah. Right now, according to The Verge, Judge Koh is going over the document. She says she wants to review the verdict before proceeding.
We're just doing a breaking news special.
She is looking at the verdict form, according to The Verge.
21 hours of deliberation. That's amazing.
According to the San Jose Mercury News, question 1 out of the box will be whether Samsung infringed the so-called bounce back feature. So people, experts say, watch the results of that first verdict, and that will kind of give you a hint as to how the rest of the verdict will go.
Right. Well, I mean, that's really, if you look down the list of patents that Apple say was violated, that is the strongest. That's definitely the strongest, because you can make a case that there were so many different ways you could have done that, but you copied the look and the feel of the Apple feature.
That's the three. That's go ahead, Jason.
I was just going to say Denise is confirmed. She's going to be coming on in about 5 minutes.
Great, thank you. That's the patent that they colloquially call 381, and the one that, in fact, Judge Koh said was the most important patent of the 4. It's kind of a silly patent, and it's funny that should be so important in this. This is the patent, and anybody who's used either an Android or an iPhone knows that when you get to the end of a scroll, there's a little bounce, a little doing, where you see nothing, and then it bounces back. That is patented. Apple patented in December 2007. But Samsung says it's an invalid patent, and we have one that dates to 2005. And so it was Samsung's contention that there's prior art and that it is an invalid patent. I'm going to ask Denise this. Denise Howell, who is the host of our This Week in Law show, is also an intellectual property attorney, so she's uniquely qualified to talk about this. But it is my understanding that a patent is granted, but really it is often up to the courts, and in this case a jury, to really validate it. That it is almost, the granting of a patent is almost tentative until such time as it's confirmed by a jury.
Jury's coming in.
Yeah.
We're going to have Denise and Tom on.
Good. Denise Howell will be joining us in a few minutes. Tom Merritt as well.
Yes.
Jury has now walked back into the room, and according to The Verge, poker-faced to a person. You know, juries take this stuff very seriously. I was fortunate enough to be in a jury about it almost exactly a year ago. And if you didn't take it seriously going in, by the time you get through the selection process and the trial begins, I think you realize how important it is. And in a trial like this, where Apple is asking for $2.5 billion in damages, I think very quickly it becomes clear that this is something quite serious. And W.G. Finley in our chat room says the jury is poker-faced and Lady Gaga wants her royalties.
I have a classmate from university who he went into law, but he's not a lawyer. His specialty is picking juries, and it's all he does. He's really good with psychology. He's really good at looking at the way that questions are answered during the WAD process. And you know, what he was saying when I asked him about this trial was, you don't necessarily want tech-savvy people on this jury, which I blew me away. You figure both sides would want people who understand the tech, but that's not what they were looking for.
Right.
They were looking for people who would either...
The judge has just asked the jury, have you reached a verdict? The jury has said yes. So I believe we're going to start hearing this.
Yeah. We have Tom on, by the way.
Tom Merritt, are you there?
I am. Hey, Leo.
Thank you for joining us. I sent you an email about 10 minutes ago saying, and of course, because we're trying to decide what breaking news coverage to do, it's going to be a very big 2 weeks with Nokia, Motorola, Google, Samsung, and Apple making big announcements. Oh, Amazon, too. And we're deciding which breaking news stories we'll be doing next week. And I said, and don't forget, probably next week or the week after, there'll be an Apple-Samsung patent verdict. And my God, we have one already.
The next couple of weeks for a verdict. And honestly, all the stories this morning were saying it's going to take them over the weekend. This is a very complicated form. Remember, they have 84 jury instructions to get through. They'll definitely won't have a verdict before Tuesday, but it probably won't go past next Friday because the judge won't allow it. And here we are. They're in court and they're going to announce a verdict shortly.
You were saying, Robert Ballecer, that your jury selection expert said it contrary to what one might expect, a technical jury is probably what you wouldn't want here. And really, isn't that what this is all about, is what the common person might think looking at a Samsung product, whether normal people would be confused, not whether you or I be confused. Of course, we wouldn't be, but whether a normal person. The judge is now asking the foreperson of the jury, Ms. Parker Brown, to read the verdict. So this is going to come across any second now. The verdict is being read.
All right. We have Denise on the line as well.
Denise Howell joining us, host of This Week in Law. Denise, I'm sure you're
nice to see you.
Nice to see you. I'm sure you're as surprised as we are to be here on a Friday. The jury only got this case on Wednesday.
Right.
They've decided very quickly. Is it unusual to have a 20-page verdict form in a civil suit like this?
Not in a case like this. No, not where the issues are so complicated and the jury has to rule on so many separate things. A jury form like this makes sure they don't miss anything, makes sure they cross all the T's and dot all the I's.
Starting with Apple's claims right now. It's so exciting.
They're reading the verdict as we speak. If you're just joining us, breaking news. The jury has, in 2 days, come back with a verdict in the Apple versus Samsung trial, and they are now reading the verdict live in court. There are several live blogs. We're following the San Jose Mercury News' live blog, and we are also following The Verge. The Verge has done an excellent job of covering this all along.
Now, Denise, they're going to read each patent separately, right? Because they have to come on a decision on each patent.
They do. They have to come to a decision.
Here we go.
Here we go. Go ahead, Leo.
For each of the following products, did Samsung infringe Claim 19 of the 301 patent? Yes. So for the bellwether patent, the one we were paying the closest attention to, this 301 patent, the jury has found in favor of Apple. For SEA Galaxy Tab Wi-Fi, yes. For Captivate, it looks like it's going Apple's way in every respect.
And this is
here.
Broader than the decision we heard about in Korea yesterday.
Which went the other way. Well, it was kind of mixed.
Samsung was found to violate the bounce back patent, but that was it. Apple was found to violate 2 Wi-Fi patents in that case.
So in this case on bounce back, Apple's claim of infringement has been approved. The bounce back patent, the jury has said, Samsung, yes, you did infringe. Continuum, Droid Charge, Exhibit 4G, Galaxy Ace, Prevail, the Samsung 4G, S2, Galaxy Tab, the Gem, Indulge, Infuse 4G, Mesmery, Nexus S 4G, Replenish, and Vibrant, all infringed. Question 2, Claim 8 of the 915 patent. Denise, do you know what the 915 patent is?
No, I don't.
All right, we're going to look it up. They're using the last 3 digits of each of these patents, of course, because it's such a long number. It's in the millions. This is the scrolling and zooming patent that Apple claims Samsung infringes in 24 of its products. We're watching carefully.
And remember, this is not about whether they look alike. There are some claims about that, but this is about particular patents and whether they actually mimicked the functionality directly.
Now, yes. In every case, all 24 products, Samsung does infringe on Apple's 915 patent. Denise, if the jury, and it looks like the jury will find in Apple's favor in almost every part of this complaint, what happens then for damages? Is that part of this decision, or is that a separate part of the trial?
I am not terribly certain whether they segregated out damages here. It's all part of the verdict form. If damages are to be awarded for the infringement and the damages evidence has actually come in, then they would do it now. But what typically happens in cases like this is that they wait for an infringement determination first, and then they go on to the damages phase of the trial. Because this trial was abbreviated to begin with, I think that might be what happened here, but I have not been following the day-to-day coverage, so I really can't tell you.
You know, there is, one victory for Samsung here on the, looks like on the 915 patent. Not the intercept and the replenish do not
two
infringe.
Phones that you're like, what phones?
The but so this is interesting. They're going. This is why it was such a long verdict form. They have to say on each of the 24 products whether those products infringe. We're now up to claim 50 of the patent 163. This is the 163 patent, which is, I'll tell you in a second.
If you're following along on the blogs, folks, SEC means Samsung Electronics Corporation. SEA is Samsung Electronics of America, and STA is Samsung Telecom. So there's three different Samsung divisions or corporations that are being cited in these cases.
So this patent is that tap to zoom patent, where on an Apple iPhone, if you tap a portion of a web page, it zooms into just the right size of it, and it is Samsung. SEC did infringe on the Charge, the Epic 4G, the Exhibit, the Fascinate, the Ace, the Prevail, the Galaxy S, the Galaxy S 4G, the S2, the i90-100, which I think is the Note, the Samsung 2 for T-Mobile, the Galaxy Tab, the Tab 10-1, and Fuse, Mesmerize, and Replenish. However,
at least they're not giving them the actual model numbers for things like the Tab.
Yeah, no kidding.
The
however,
SCH113, that would be ridiculous.
However, the double tap to zoom 163 patent was not infringed on the Captivate Continuum Gem Indulge Intercept Nexus S4G. That's interesting because that's the Google phone. Transform Vibrant, but it was infringing on the Fascinate and it was infringing on the Galaxy Tab 10-1. So
there's lots of implications for the yeses and nos within these, but the general trend here seems to be that the jury is finding that Samsung did infringe patents in most of the phones.
Yeah. And then, so again, the abbreviations are SEC, Samsung Electronics Corporation, SEA. What does that stand for, Tom?
Samsung Electronics of America.
So that's the American
STA is Samsung Telecommunications of America.
Okay. So phones for STA, tabs for SEA in the U.S., and SEC is, I guess, phones as well.
Yeah, those are phones that are generally made in Korea and then imported here rather than sold directly by Samsung in America.
Now we go to question 4. For a list of 21 smartphones and tablets, has Apple shown that Samsung took action it knew or should have known would mean its U.S. subsidiaries would infringe those 381, 915, and 163 patents? In other words, did Samsung knowingly infringe?
Yes, for all devices.
And
on
yes,
the bounce back patent.
For all devices. So that's called inducement, right, Denise? That's they found in favor of Apple on the inducement charge.
Yes.
So we know it's not going well for Apple. I mean, for Samsung.
For Samsung.
Yeah, it's going very well for Apple. Question 5, for each of a list of 13 smartphones, has Apple shown that Samsung, Korea, or U.S. has infringed on the D677? This is the trade dress issue, the registration of the look of the front of the iPhone. That's the next question.
This is the do they look alike question that everybody talks about.
381.
Yes.
That is the infringement patent. So we're still on the inducement section of the jury verdict form, a 20-page form. So there's going to be quite a bit here. And by the way, one of the reasons it's 20 pages is not only do they have each of these individual issues, but they have to do it for each of the devices. And in some cases, there's as many as 24 different devices in the complaint. So that's a lot that the jury has to go through. Interestingly, the jury is really going device by device. For instance, they've ruled there was inducement on the 915 patent. That's the pinch and zoom versus scrolling patent on all the phones except the replenish. For some reason, the replenish doesn't violate 915. On the 163 patent, which is the double tap to zoom patent, yes on the Droid Charge, Epic 4G, Exhibit, Fascinate, Galaxy, Prevail, on and on and on, but no on the Captivate, Continuum, Gem, Indulge, the Nexus S. Again, I think the only thing important here is pointing out which ones are the pure Google Experience phones. It'll be interesting to see if the jury does exempt the pure Google Experience phones. So far, it's a mixed bag. I see Nexuses in both infringing and non-infringing. Now we're going to talk about the trade dress patent D677. This is does the Samsung phone look like the iPhone? Did it infringe trade dress? Denise, are you at all surprised with any of these verdicts? Are you surprised with the granularity with which the jury is coming back?
I'm not, because this whole case has been about the granularity. As you have seen the evidence come in, they've heard and entertained evidence on each and every one of these claims. So that's, how they have to rule, and that's why this verdict form is so detailed, is to enable them to be able to jump through all those hoops.
The jury has ruled for Apple on the trade dress infringement on the Fascinate, the Galaxy S. That is a Nexus, a Google Experience phone. Is that not?
No, the Galaxy S is not.
That's not. Okay.
Right.
The S2 for AT&T, the European S2, the S2 for T-Mobile. They're even going carrier by carrier. The S2 Epic Touch 4G, which is the Sprint phone, the Skyrocket, Showcase, Infuse, Mesmerize, and Vibrant. It does not infringe. The Ace didn't look like an iPhone, apparently. We got to get a picture of the Ace to see how that...
Ace, I think, had a keyboard.
Yeah.
Is that the difference?
But the Galaxy Ace didn't, so I'm not sure which Ace this is.
For STA, yes, they did infringe trade dress. The front of the phone did confuse with Apple's front of the phone for the Galaxy S4G. The S2, this is just the American versions of these phones.
Wow, and the D087 patent, which is the back of the phone, which is, I thought, probably the weakest argument, they're saying yes for several of these phones.
The i9000, that's the European Galaxy S. The 4G of the Vibrant, no for the back of the phone for AT&T, the European, and the Sprint 4S2. It does not infringe. That's very confusing.
Question 7, finally.
The D305 patent. What's question 7? Do you know? That's the trade dress registration of the iPhone's home screen. This was the claim that the home screen on the Samsung phones was a direct ripoff of the iPhone's home screen. It's question 7.
No, the S3 is not listed in this case. It was not listed in the Korean case either. Someone in the chat room just asked about that. Neither is the 4S, I don't believe.
Judge Koh actually, it was originally in the complaint, and Judge Koh said we can't do all of these phones. You're going to have to pick and choose. And Apple, as my understanding, Apple said, all right, we'll leave out the more recent stuff. We'll go for the older stuff. The D305 patent, the home screen patent, Samsung did infringe on Captivate, Continuum, Droid Charge, Epic 4G, Fascinate, Galaxy S i9000, the S4G, the Showcase, the Gem, the Indulge, the Infuse 4G, the Mesmerize, and Vibrant. I think that's all of them.
All of the Samsung TouchWiz
TouchWiz,
phones.
effectively they're saying TouchWiz did infringe on Apple's trade dress for the home screen.
I find that
Samsung's losing this.
This
apparently. Is going very, very poorly for Samsung. For Samsung America, Captivate infringed on all of them. That's it, all of them. They did not, it looks like they didn't, it was TouchWiz that they were going after, because I don't see any Google Experience phones in this list.
And just listening to the granularity of all this, there's no way that they've had damages evidence yet.
They couldn't possibly.
No, they can't. They can't get to that until they determine what's been infringed here.
Now that we get to the jury, just felt like Apple made the case, and they didn't have much to talk about because they came back quick and they came back with a yes.
Yep. We're now looking at the iPad. The question whether this is question 8, whether the Samsung tablets infringed on trade dress, in other words, confused people with the iPad. No, across the board.
There goes that theory.
Samsung won when it came to tablets. So it looks like they've lost in phones, but at least so far, they've won in tablets. Now,
that was a patent that they tried to bring in 2000 as prior art.
Right. That's right, 2001: A Space Odyssey. The judge did rule against that, but apparently the jury had some some knowledge of it. Now we only have a few more questions. The inducement question, has Apple shown that Samsung Korea knew or should have known it was inducing Samsung U.S. and subsidiaries to infringe these trade dress patents? This is question 9. This, according to The Verge, will be one that will be a big impact on how damages are determined because, of course, if Samsung knowingly induced its U.S. subsidiaries to infringe, and it's yes.
Whoa.
It is yes across the board. Was Samsung willful in its infringement? Yes.
That very celebrated series of emails and the presentation graphic where they broke down all the things in the iPhone they wanted to imitate swayed the jury. And the jury said, yeah, look at this. You laid out a plan to imitate the iPhone, and we feel like you did. That's what it sounds like is being said here.
So willful infringement, that doesn't sound good. An inducement does not sound good for the damages phase of this. Remember, Apple's asking for $2.57 billion in damages. I'm not sure if Apple's asking for the court to forbid sales of these products in the U.S. Most of these are older products, so it probably wouldn't be a huge loss. Ah, interesting. Okay, you're going to have to parse this one. This is a little complicated. So we're doing question 9. Was Samsung willful? It was for the phones. It was not for the tablets.
Well, for the D889, they found no infringement
for
across the board.
Yeah.
So it makes sense that they would find
okay. You're right. They couldn't say it was willful. You're right. Absolutely. Yeah. They didn't even find infringement.
D87, which one was that?
This is not willfulness.
Did you see on
I'm
The Verge,
sorry.
The last question was whether Samsung should have known.
This was inducement versus willfulness, right? Is that right? Am I?
Whether you should
read you
have
the
known is what you were on notice of, what you would be imputed to know, even if you say you didn't actually know it.
So they're dealing with question 9, which is: has Apple shown that Samsung Korea knew or should have known it was inducing Samsung U.S. subsidiaries to infringe? The next question is: was it willful? The next question after that will be a big one. Has Samsung proven that Apple's asserted utility and/or design patents are invalid? That is, has Samsung invalidated any of these patents? So we are...
Well, and that's an interesting point of the case, right? The jury could say, like, oh, yeah, you infringed all these patents, but they're not any good.
Right.
And that could change this whole all around.
Seems unlikely that they would come up with these decisions and then turn around and say, oh, but by the way.
And as far as willfulness, it sounds like yes for all but 087 and 889, yes for the other 3, and yes for all but the tablet ones as well.
Again, tablet, no, but everybody else, yes. Now we get to invalidity of patents. And this is the last question in the patent section. We're going to move to trade dress next. Has Samsung proven that Apple's asserted utility and/or design patents are invalid? Has Samsung proven its case that the patents are invalid? No, across the board. Not a single patent was proven invalid by Samsung. That's a decision in Apple's favor. You have to think that they're going to, that once we get to damages, they're going to give them everything. The only exception to any of this has been a handful of handsets and the tablets. In every other case, Apple has proven its case.
The interesting thing here is, I mean, it's the handsets that Samsung's really making moves on. They don't really have much of a foothold in tablets. Those are the only ones that are making it through.
Right. Yeah, you're right. The phone market is the one that's the most threatening to Apple at this point. Are there any Google Experience phones in any of these infringing? I don't think so. I think these in every.
I've been looking for them. I don't see.
I mean, the Nexus S was early on,
and that's the only one.
That's the only one that we saw.
And they found
Apple has proven only the iPhone 3G trade dress protectable.
Wow, that's interesting.
In other words, the 3GS and the 4 not protectable?
The choices for the jury were iPhone 3G, iPhone, iPad. And the jury chose iPhone 3G. There's an iPhone. You know, this is a strange question because...
Denise, I'm totally confused. What does that mean? So Samsung has not proven that 893 trade dress is not protectable, but Apple has only proven that the iPhone 3G is trade dress protectable?
Right. 893. Go ahead, Denise.
That's okay. Has not proven that 893 trade dress is not protectable.
That's a double negative.
Yeah, it's a double negative.
Good luck parsing that.
Sure.
Now we're going to talk about dilution. If the registered iPhone trade dress is famous, reads the question, has any of a list of 17 Samsung phones diluted Apple's trade dress? What does that mean, Denise?
It means that Apple has an identifiable design feel to the phone, and if you have been using their trade dress without a licensed ability to do so, then you're taking away from that brand identity.
Diluted the value. And in this case, the jury has ruled it has diluted the value in the case of the Fascinate, the i9000, the Galaxy S4G, the Showcase, the Mesmerize, and the Vibrant. But the Captivate, the Droid Charge, the Epic 4G, the S2, the Epic 4G Touch, and the Skyrocket and Fuse 4G do not dilute Apple.
Now, Denise, isn't the dilution of the brand, that's a big consideration in the awarding of damages, right? I mean, if you're not diluting the brand, yes, you get penalized for infringing on patents, but if you haven't diluted the brand, you don't get hit with as big of a judgment.
I believe that's true. I am not a patent lawyer, guys, so bear with me here.
Come on.
Make my way
Come
through
on,
like
Denise. Make it up. That was question 15. If the registered trade dress is famous. Now, question 16, the unregistered trade dress. If the unregistered iPhone trade dress is protectable and famous, have any of the 17 phones diluted it? That means, in other words, even though Apple has not registered these, it still dilutes Apple's value, and the jury has ruled yes. The Fascinate, the Galaxy S i9000, the S4G, Showcase, Mesmerized, and Vibrant do dilute Apple's unregistered trade dress for the 3G. By the way, that's the same they ruled on question 15. Same phones, in other words. So there's some consistency here.
Except you've got the i9000, which was positive on this one, and it was negative on the previous one. It's the same phone.
Parse that, please. This is really, I don't know how the jury did this in 2 days. It must have taken them 2 days to check these boxes, let alone make the decision.
They must have had really good graphics.
I think so. So this is saying that the unregistered trade dress, that is the way the 3G looked that Apple did not attempt to protect with a patent, was that copied, and does it dilute Apple's value? And the jury says yes for some phones and no for others.
To kind of sum her up, the jury has found Samsung infringes Apple utility design patents for some but not all the products. Willful infringement on 5 of 6 patents, have upheld Apple's utility and design patents, upheld Apple's trade dress, and found that Samsung diluted the iPhone trade dress on some products but not others.
Now, we've been talking about the 3G. Now they're going to talk about the combination iPhone trade dress. That is the trade dress that is common to all versions of the iPhone. I guess when we had that 3-part question, has the Apple iPhone been, has Apple proven it's protectable? They had the choices of 3G, iPhone, iPad, and they chose 3G. So now we're talking, when they say iPhone, they mean all iPhones. This is question 19. There are a total of 33 questions, so we're a little more than halfway through here. 19, by the way, is, was this dilution willful? I think we've skipped a question. At least The Verge might have either not reported on it, because I don't see a result for 18, which is the tablets. 17 was combination iPhone trade dress. 18 was
damages.
Tablets. They are going to rule on damages?
Damages?
Wow.
So no on iPad trade dress, no for unregistered iPhone trade dress.
Okay, so that's consistent with what they ruled earlier, which was it was 3G, infringement on the 3G trade dress, both protected and unprotected, but not in general on iPhone or iPad.
Woo! Galaxy Tab 10.1, Wi-Fi and LTE. If I'm reading this right on the CNET Live blog, 1.5 billion.
Oh, boy. Yep. $1,051,855,000 to be exact.
I'm glad The Verge gave that same thing as well.
And they wrote it out.
Yeah, they did.
Like a check. And that's what Apple's going to get from Samsung. I presume there's an appeal, or is there, Denise? Is there? Do they have the opportunity to appeal this?
They do.
Okay, so this could go on.
Yes.
Yeah, we'll be doing this again. Don't worry.
We will.
And there's another case going on across the continent between these same companies.
Yeah, and of course,
And
Motorola.
there will be post-trial motions that challenge the damages, and before they ever get to the Court of Appeal, they will attempt to find some sort of fault with the trial and the jury verdict.
Right.
Now they're going phone by phone to questions 21 through 22. Captivate, 80.4 million. Continuum, 16.4 million. Droid Charge, 50.67 million. Epic 4G, 130.1 million. Exhibit 4G, 1.8 million. Fascinate, 143 million. Galaxy,
0. That's interesting.
That is interesting.
Galaxy Prevail, 57.86 million.
The next section, and there's only a few questions in this one, 9 questions, are whether Apple, these are Samsung's counterclaims against Apple. So Apple's pretty much won in almost every respect in its claims against Samsung, but Samsung did make counterclaims. There's also a monopoly question, which we'll get to in a little bit.
Well, that's what happened in Korea. In the Korean decision yesterday, Apple got awarded more damages than Samsung, but Samsung got awarded damages too. So it ended up balancing out to be not that much money exchanging hands at the end of the day.
I'm still waiting for the bulk of the damages. I mean, I don't see it yet.
Epic 4G, 100.325 million.
Yeah.
You know, 100 million here and there, it starts to add up.
It's real money.
They're nickel and billioning them today.
They're billion and
But I mean, if you're just
millioning.
tuning in, you're watching, of course, live coverage of the jury's verdict in the Samsung-Apple case. They came back fast, 2 days after the jury was given the case, and in almost every respect, they've decided in Apple's favor. We're seeing damages well in excess of $1 billion. That's the phase we're going through right now, is a list of damages. Yeah, I think the Verge has stopped updating, so I'm going to move on to CNET, I guess.
They passed out.
He wrote that number, and that was it.
I'm surprised the jury hasn't passed out. They crammed so much into this little short trial.
They had 109 pages of instructions, which they digested, and a 20-page verdict form, which they filled out all in 2 days.
The Verge is back. They were just kind of totaling up some of these smaller numbers.
It looks like a big chunk, a quarter of the damages were awarded for the Epic 4G, because that comes up several times.
You know, $53 million for the Mesmerize. I can't imagine Samsung even made that much on the Mesmerize. $53 million.
Whereas the S2 variants aren't actually being tagged all that much.
The Prevail, $57 million. These are the early Samsung Android phones. The Infused 44.7 million.
This is how they got to that 1,051 million.
Are these the
number,
parts?
Yeah.
Okay, so this is.
I think they're going through the shopping list.
Okay.
For each of the following products, has Samsung proven by a preponderance of the evidence that Apple infringed the indicated Samsung utility patent claims? For the iPhone 3G, no. For the 460 patent, that's for the 711. For the 460 patent on iPhone 3G, no.
No, for the 893 on the 3G.
So
these are Samsung's counterclaims.
Right.
Yeah.
All
so this is an extra bad loss for Samsung.
They didn't get the two-way verdict that they got in Korea. These patents are things like the standard for 3G, multitasking on a mobile device, bookmarking. These are patents that Samsung claims Apple infringed. Bookmarking a photo on a camera-equipped phone and use of email in a camera-equipped phone. These are all patents Samsung has.
No on all these claims.
So the jury is definitely...
it's a clean sweep for Apple.
The jury's going along with Conan O'Brien on this one. I think that was kind of a bellwether. Once a mainstream television show kind of says, this is obvious, and apparently the jury felt that way. Of course, they didn't see that joke video from Samsung on Conan O'Brien, but they're kind of ruling as if they did. Again, the 893 patent, no. Apple did not infringe. The 460 patent, no. Apple did not infringe on Samsung's patents. So there's no small victories for Samsung in this at all.
No iPad 2 victories, nothing. They are striking out.
So there could have been in this part damages in Samsung's favor, but of course they have to find some infringement, and so far the jury has found none.
No on the iPod Touch patents.
So looks like a total loss for Samsung on this.
Samsung's like the Sammy Khalifa of patent.
Which is interesting because Coe disallowed the introduction of the Samsung, was it the F700? The media player that was released a year before the original iPhone that looked really, really like the iPhone, because she said that it's not a phone, it's a media player, so therefore it can't be introduced. I'm wondering if that is, can that be introduced in the appeals process, Denise, or that since it was disallowed in the first trial, it cannot come back in?
I'm sorry, can what be introduced in the appeals process?
So Samsung had a device a year before the original iPhone called, I believe it was the Samsung F700. It really looked like the original phone. It had rounded corners. It had icons. It was a touch screen. But Coe disallowed it because it was a media player and not a phone. Can they bring that into the appeals process, or that's disallowed?
The only thing they might be able to look at on appeal, if it's an issue that was outcome determinative in the case, is whether she could properly exclude it.
So here's the jury's awarding $0 in damages to Samsung from Apple. The next question could be fairly important. Has Apple shown that Samsung's patent claims are invalid? The jury could at this point invalidate these patents that Samsung claims.
Has Apple proven by a preponderance of the evidence that Samsung breached its contractual obligations by failing to timely disclose its intellectual property rights during the creation of the UMTS standard, or by failing to license its declared essential patents on fair and reasonable terms? No, Apple has not proven that Samsung breached its obligations. Apple was trying to say Samsung needed to license these to us, and they wanted to charge us too much money. They were breaching the terms of a fair, reasonable, and non-discriminatory licensing. The jury says no, they didn't.
That's just an extra in case they lost the previous questions, which they didn't. So this portion of our breaking news brought to you by our friends at Slingbox. As always, Slingbox makes breaking news possible on the TWiT network. Get your Slingbox at Amazon, Best Buy, or Slingbox.com. If you want to know more, go to slingbox.com/twit. It's a great way to bring your TV wherever you go, especially on the iPad. We're watching breaking news coverage of the jury decision. It has been very bad. I don't think you could get much worse for Samsung.
No kidding. How critical is something like this? I mean, for a company as big as Samsung.
I think really the question is going to be, and obviously we have to go to appeal, the question is going to be not these devices and probably not even this amount of money. Samsung, after all, has made a lot of money last quarter.
Exactly.
But how it applies to the current crop of phones, the S3, which was not in this case, the Galaxy Note, the new Note tablets, these are all new products that Samsung is hoping to do well with. These are all older products that Samsung doesn't care if the Fascinate, if it can't sell
if it isn't on sale anymore, but chances are a lot of this stuff is also existing in their current devices as well.
So they're wrapping up.
Apple has been found, or that Apple has proven that Samsung violated the Sherman Antitrust Act in regards to patent 914. If I'm reading this right.
Has Apple proven by a preponderance of the evidence that Samsung has violated Section 2 of the Sherman Antitrust Act by monopolizing one or more technology markets related to the UMTS standard? Yes and yes. Now, again, this will be appealed. There'll be a lot of post-trial motions on both sides. There are a lot of places where Samsung could say, hey, Judge Koh made a mistake in not allowing pieces of evidence introduced. But Apple's certainly taking a moral victory here. I mean, a total moral victory here.
Yeah, there's no mitigation here. Samsung did not failed on all of their claims.
Yeah.
Apple has succeeded on all the ones they cared about. Now, the question is, Apple now needs to carry this to the next generation of devices because a lot of the devices here are not the current crop. They're not the ones that are selling big.
Yeah, but significant, the jury has invalidated a number of Samsung utility patents going forward that could be very significant. I would guess could be very significant.
So could we see the next round of Apple lawsuits against Samsung even as this one is being appealed?
You bet.
Because they still have to go after the Note. They have to go after the Nexus. They have to go after the S3.
iBookery in our chat room says the next Samsung phone will be the Samsung Capitulate.
The Samsung Donate.
If Steve Jobs is watching up there, this is exactly what he wanted. He said
absolutely.
This was his nuclear option.
Nuclear war against Google, not Samsung, but Google by proxy, I guess. I think that's it. It does seem that there are some questions that, at least in the live blogs I'm seeing, haven't been answered. For instance, has Apple proven that Samsung is barred by patent exhaustion from enforcing its utility patents? I didn't see an answer to that. That's the last question, question 33. Or how much is Apple entitled to receive in damages for the antitrust violation? Did you see anything? I didn't.
Yeah, on The Verge, it says 516 yes, 941 yes.
Okay. So those have basically been invalidated at this point. Patent exhaustion. What does that mean, Denise? That's how the jury feels.
It means what you have after reading through this verdict form.
That's how the jury feels after this.
Yes.
Yes, The Verge says Apple didn't win everything, not by a long shot, but it won enough to make this a very important day. I would say it was actually a pretty much total victory by Apple. The jury's now going to the jury room. Judge and lawyers go over the verdict form. $1 billion plus in damages for Apple from Samsung. Samsung loses rights to a number of its utility patents.
So patent exhaustion is the doctrine that limits the extent to which patent holders can control a patented product after an authorized sale. So it's a first sale kind of concept. It's how much you can enforce downstream.
The jury did find that Samsung had not violated Apple's antitrust rights. So there you go, a victory for Samsung.
And of course, the markets are already reacting. We've got Samsung down over Google down over $7 in after hours, and Apple's up over $11 in after hours.
What about Samsung?
They're no longer trading Samsung.
The jury found that Samsung's infringement of Apple's utility design patents for some products, but not all, mostly phones, not tablets. The jury did uphold Apple's utility and design patents, trade dress patents. They did find that Samsung diluted Apple's iPhone trade dress on some, but not all products. Samsung lost its contention that Apple had infringed on its utility patents. And the jury did find that Samsung had violated antitrust law, monopolizing markets. The total damages we're still adding up very close to what Apple was asking, $2.3 billion, according to CNET.
According to Bloomberg, Samsung stock down 12,000 won, but that's just about 1%.
It's about $5.
Big company, and phones are not, unlike Apple. An iPhone is Apple's biggest business. It's not Samsung's biggest business by a long shot, I'm sure.
Does this potentially not affect at all Samsung's kind of current relationship in other ways with Apple?
Well, that's a question we've been asking all along, and it's been kind of our feeling, and I think it's been borne out, that Samsung's a very big company with big different divisions, and that Apple continues to use Samsung parts in the iPad and the iPhone.
And a good example of this sort of thing happening in a company is Sony, where you have one part of Sony out there trying to shut down the devices made by another part of Sony from playing movies, because you have Sony Pictures not wanting them to be their fear of piracy being played on Sony products, and Sony Electronics saying, no, we don't want to impose DRM. So you can have Apple talking to one part of Samsung, which says, look, we don't have nothing to do with those phone making guys. We're just making chips for you. Please don't hold it against us.
Doesn't mean, though, that the Samsung guy's not going to spit in those chips before it delivers them. That's all I'm saying.
But I mean, Samsung Electronics is not going to bar their biggest customer for screens, for memory, for processors.
Cut off their nose to spite their face.
Exactly. Right. I mean, that would cost far more than $2.5 billion.
Exactly. But on the other side, Apple has been sourcing its parts from other manufacturers. Right. They're going to TI, they're going to LG. They're trying to find other sources for memory and for screens. So I think Apple they're getting to the point where they don't need Samsung anymore, but Samsung still needs their number one customer.
If you're just tuning in, the verdict is in on the Apple versus Samsung case. In almost every respect, the jury ruled in Apple's favor. Damages of over $2.3 billion. Samsung will, of course, appeal, and there'll be a lot more legal wrangling before this case is over. But a big victory for Apple today. The jury coming back after less than 2 days with this kind of resounding victory for Apple. We thank our friends at Slingbox for making our live coverage possible. Slingbox, you hook it up to your home theater system, your DVR, your satellite, your cable, and then the internet. And now you've got password-protected access to your home theater system. No additional charge. You already paid for it. It's yours on the iPad, the iPhone, and a variety of devices, of course, your laptop computer, too. Get yourself a Slingbox at Amazon or Best Buy. Find out more at slingbox.com/twit. We thank them for their support of our live breaking news coverage. This is just the beginning of a big 2-week period of breaking news. We have announcements coming up from Nokia, Motorola, Amazon, and, of course, Apple, we think, in September 12th. So I know, Tom, you'll be busy this week covering this stuff. Tom Merritt.
Yeah, finally, we're getting out of the August
doldrums.
Desert of tech news.
A little too much tech news this week. Thank you so much, Tom Merritt, the editor-in-chief of TNT Tech News Today. He'll be back on Monday, and I'm sure this will be the topic of discussion. Thank you for being here, Tom. We really appreciate it.
Sure, yeah, no problem.
Denise Howell from This Week in Law, our legal counsel. We appreciate our consigliere here at the TWiT Network.
Yes, we'll look forward to seeing how all this shakes out as they determine whether the damages were properly calculated and start formulating arguments for appeal.
Will you be? I presume that this will be a topic for conversation on Twill.
It has been and will be.
Yep.
And we get great patent folks on to help us try and parse it all because it gets a little in the weeds.
Thank you, Denise. Denise Howell, last minute, we appreciate it. Same with you, Tom Merritt. I know you were probably relaxing.
I was raiding in Magister's Terrace looking for grinding out a pet when I got the text
Back
message.
to your grind. Thank you, Tom. And we were I don't know if we interrupted Father Robert Ballecer's pre-taping of This Week in Enterprise Tech.
Oh, no, not at all. No.
Yeah, okay. You want to get back to work?
At some point.
All right, we're going to let you get back to work. We thank you all for joining us. Breaking news coverage. Once again, if you're just tuning in, big victory for Apple versus Samsung. Still no word whether Samsung will appeal, but I guess with a $2.3 billion judgment against them, they're probably going back to court. Thanks for joining us, everybody, and we return you now to your regular programming already in progress. Thank you, Jason Howell, by the way, all about Android, and I imagine you'll be talking about this on Tuesdays.
A little bit, yeah.
Yep. All right, take care, everybody.
Thank you.
We're going to run out of here. Bye-bye, Denise. Bye-bye, Tom. Back to your grind.
I, for one, welcome our new Apple overlords.
I'm a little surprised, to be honest.
I am too.
I thought this was a complicated case, and I know that in our conversations on Mac Break Weekly and other shows, it was really touch and go. But obviously the jury felt pretty much the same way I think a lot of regular people did, that it was obvious that Samsung had copied Apple.
But, I mean, the gap is so wide there between the regular person and the techie, because there's so many techies who look at the lineup of phones and say, okay, look, does Apple have a claim? Absolutely. Should they get some damages? Probably. But the level of the number of decisions against Samsung in this case were just, it's crazy.
They were spanked.
They were absolutely spanked. This was a legal smackdown.
Yep. Well, as they say, thank you for your service. You may go back to your regular life.